With the spread of disparate impact liability to housing, credit, and education, the same logic applies. Every credit qualification will have a disparate impact on some protected group. So no action can be taken without potentially getting sued, since nobody really knows what the business necessity or educational necessity, lending necessity, no one really knows what that standard means or what it will mean to the particular federal agency that's in charge of that particular statute. Everything is prima facie illegal. So the best strategy is keep your head down. Never, never, never make clear what your employment qualifications, credit qualifications actually are. The ramifications of this for the rule of law, to me, are quite terrifying. When everything is potentially illegal, political favoritism becomes the deciding factor. For what it's worth, it is pretty near indisputable that disparate impact liability was not intended by Congress in 1964. As civil rights movement historian Hugh Davis Graham put it, disparate impact liability, quote, would have been greeted with disbelief in 1964. Instead, disparate impact liability was the brainchild of EEOC lawyers attempting to turn what they regarded as a weak statute, Title VII, into a strong one. And at times, they were quite candid about that. Alas, the Supreme Court deferred to them in Griggs versus Duke Power Company, and eventually Congress acquiesced in this in their amendments to the Civil Rights Act in 1991. So it's the law with regard to employment. But why export such a wrong-headed idea to housing, education, and credit? Among other things, as I said, it is quite possibly unconstitutional. Strict scrutiny is a tough standard. Any law that is intended to confer benefits on a particular race or particular national origin group over another must have a compelling purpose and be narrowly tailored to serve that purpose. So far, no one has made a plausible argument as to how generalized disparate impact liability standards can survive strict scrutiny. The U.S. Commission on Civil Rights stated that disparate impact liability, quote, cannot be sensibly applied to white males, close quote. I will note that neither Pete nor I had anything to do with that statement. Given its purpose is to uproot institutional sexism and racism. In 1991, members of Congress stated over and over again in amending the Civil Rights Act that the law they were adopting was intended specifically to assist women and racial and ethnic minority groups, to give them a leg up. And scholars have agreed. Disparate impact liability doesn't apply to white males, although white males have been known to bring such cases. To my knowledge, none has been successful. Okay, if so, that's enough to trigger strict scrutiny right there. And one scholar has said that he used to firmly announce to his students that disparate impact theory is not available to whites and males, but he realized when the court began to make it clear that strict scrutiny applies on behalf of majorities as well as minorities, in cases like Grutter versus Bollinger, the court has said it. This scholar said he began to realize that in applying disparate impact theory, doing so one-sidedly would require that strict scrutiny be applied, and that, of course, would raise very serious constitutional difficulties.